For the state of Ohio versus Exakaya Rouse. Mr. Rouse is before the court with his counsel, Mr. Gibbs, Ms. Tranter. On behalf of the state of Ohio, we are here for sentencing. Preliminarily, I will state for the record that Mr. Rouse has filed two separate appeals. I don't know that he has necessarily appealed the issue with regard to the jury's verdict. The first appeal was dismissed by the 12th District Court of Appeals. As far as I can tell, the second appeal is still pending. I do intend to proceed with sentencing today. It's my thought, my belief that that appeal will also be dismissed as being untimely, and that I also know that there was a federal lawsuit that you have filed against the court as other members that are present in this courtroom. Despite all of that, it's my intention to proceed with sentencing. Some of the accusations that you have raised in this in your letters to the court, in your appeal, and in your federal lawsuit are to me outrageous, but that's your position, and that the court intends to proceed with sentencing today. So with all of that, Ms. Tranter, is there anything from the state?
Yes, Your Honor, just very briefly. From the state's perspective, Your Honor, this case is all about punishment. This is not a rehabilitation case. Actions and convictions that we're here on today represent an attack on our electoral process, which is the very foundation of our government. This court, Your Honor, has a duty to protect that interest and the integrity of our election process. Additionally, the defendant has, as the court knows, an extensive criminal record littered with behavior very similar to what we have seen in this particular case. Forgeries, prescription falsifications, receiving stolen properties. I count at least 5 separate times this defendant has been to prison. Either an initial sentence, and there's a couple of times here, as the court can see, that he has been judicially released, for lack of a better word, onto probation. Multiple times that probation has been revoked and he has been sent back to prison or sent back to jail. He has in no way demonstrated that he has any intention of complying with any sort of community control should the court choose to go that way. And frankly, I think he would just be a problem for probation. You can't treat and help someone who doesn't recognize that they have done wrong. And it's been clear from Mr. Rouse's actions that he accepts no responsibility in this whatsoever. He was convicted on 4 separate petitions that were submitted to the Board of Elections, falsified petitions.
Thank you. Anything from probation, Ms. Sokudaki?
Nothing further, Your Honor. He does have the 2-day jail time credit.
Thank you. Mr. Gibbs?
Yes, Your Honor. I would like to note that my client, as noted in the PSI, was compliant with the PSI process. He scored an 18 or somewhat mid-range in the ORAS. He does have a history of military service and community involvement. I believe the court is in possession of a letter from his former pastor, Peter Larson, that my understanding is in attendance today in support of him, as well as some other friends from the community. Several people have reached out to me through this process as well, showing that he has a positive impact on a wide range of people. I'd also note on the criminal history that there was a substantive gap in that history. Much of it was clustered a good number of years ago. That said, we understand the court's decision in moving on this, and we just request that if a time of incarceration is deemed appropriate by the court, that the court consider possibly local jail time. Legally speaking, we would certainly request that the charges merge and be, if sentence consecutive.
Mr. Exakaya, anything you want to tell me before I sentence you, sir?
So I do agree with the state. I have been in trouble as a youth. It's been quite a while since I've been in trouble, but I did have, from about the age of 18 to about 29, I did have a lot of problems. I guess argument that I had was because I was sitting in the jail, and my medical problems, like the sheriffs made it seem like it was coming from the court. The court doesn't like when we put the sheriff's name on stuff, and that's a lot of the reason why I've been trying to write letters to the 12th Circuit and get things done, because my medical stuff inside the jail, like I peed on myself. I don't know if I can say that, but I urinated on myself the other day because my nerves went out. I'm not getting my nerve pain medication. And it's just, I know jail isn't supposed to be comfortable. And it was just making it seem like it was coming. I know it sounds crazy now, but it was making it seem like it was coming from you. And he tell me, the court doesn't like when you put our sheriff's name on things and the treatment I was receiving. So that's the reasoning behind why I've been writing so many different things to a bunch of different people, because I was under the impression that it was coming from you to treat me that way. But what I noticed is every time I came to this court, they were giving me a wheelchair, but they wouldn't when I was in jail. Have to crawl all over the place on the dirty floor in the jail. And I just didn't believe that that's the way a person should be treated. And that's why I've been going back and forth, trying to get proper treatment. As far as what the state said about the election process needs to be, secure, I do agree with that. The election process should definitely be secure. But I did want to offer my apologies to you and to whoever else for thinking that you were the one who was saying that, when it's clear that now that you weren't. There are some things that I'm going to have to do. I do believe I did file something to remove the other 12th Circuit thing that I had once I kind of realized it wasn't you doing all of that. I just hate that I even went through all of this, to hate that anybody even got affected by this stuff. It just sucks. I wish that I hadn't did all that stuff. And I mean, that's basically all I have, Your Honor. I would hope that, if I could pay maybe some restitution as well to the victims, because nobody wants to have to come from work and show up to court for stuff that they don't even know that happened. I wouldn't want to have to do that. A lot of the people that were, coming up as witnesses, they didn't even know anything had happened. So I feel like I do owe them something.
Well, let me just, I'm going to give you another chance to respond, but let me just tell you, I don't agree with the state. I don't agree that these individuals are victims in the sense like we had the thefts earlier that you sat through. Those people that had something stolen from them, they're victims. I don't consider these people that testified that their name was forged on a ballot initiative petition. I don't consider them victims. However, I do consider the people of the state of Ohio, the citizens who vote on these initiative petitions on the ballot, I do consider those people victims, but they're not individual victims. Sheriff Riley, for example, who testified in court, I don't consider him a victim of this offense. So I'll let you proceed. That's my view on it, okay?
Yes,
Go
sir.
ahead. You can go on.
Yes, sir. So no one wants to have to miss their job, to come up here and lose money, for that day. Or even the jurors that had to sit here for 2 days. If there was a plea, there wasn't a plea, but, I could have probably pled out, I don't know. But looking back over it all, it's just Monday, the case that I had in Cincinnati for getting injured in 2019, got dismissed for lack of prosecution. I was planning on going home this summer to get married, get my lawsuit, go home, get married, grab a few trucks, start a trucking company. Doesn't look like that's an option at this moment because of what I've done. So literally, I still think, that, maybe I still probably should have to pay those people for not being able to go to work and having to take away from their loved ones and their family to come here and, testify at court for something that they don't even know anything about. I grew up in foster homes, foster care, and at 18, after I got out the Marine Corps, I was just on my own. So I started sleeping in cars. And I mean, the gentlemen from church, they know this story as well. I started sleeping in cars, and it ended up, I was getting popped for sleeping in cars. It was snowing outside, it was cold. within the last 10 years, got to know who my family is. And I've been trying my best. My dad's a pastor. He's really frustrated about this because he was the one that was going to do my marriage. It's just shameful, shameful. It's embarrassing too, because like I walk in here, I was working with Mr. Ernst's office. I walk in here, we'd be helping people with what they were going through. And I watched the clerks and the same people, the sheriffs and everyone just looking at me like, man, like, you know, what's going on? And so I just regret it all. I really do. I don't believe with, you know, the fact that since I've been in Ohio, since I've tried my best not to run afoul of the law. This time I did. And there's no excuse really other than, you know, what are you thinking? You know, you're not thinking, obviously. You had no situational awareness. And then when you told me on, you know, the last bail hearing, when you just said, I don't think you realize the seriousness. So I sat back and I thought about that. And I really did. And it is a problem if someone does those sorts of things of falsifying elections. It's a problem because the wrong person can be elected when people didn't even vote that person in, or any number of things could happen. And, you know, it's crazy because I threw a children's gala with the congressman's office, and there's just so many, like all my property from my home, everything that I've worked for, like literally, like worked for the right way, everything that I've worked for is like one decision away. And I guess that's the lesson, that anything you do is one decision away. I don't know, I'm not even asking for leniency, I'm asking for mercy. Like I really need mercy here because I have had it hard, but a lot of people have had it hard, so I'm not using that as an excuse. I'm asking for a term of probation. I've sat in that jail for 50 days, listening to the stupid conversations that people have, listening to, it's just dumb. Like it's, for a person that's been educated, a person that knows better, it's dumb for me to sit there and hearing some of the stories and the dumb little things people talk about. I don't even really talk to the people in there because it's just, the conversation isn't even stimulating. It's just sitting in there and wasting away. I could be out here doing community service, giving back to the community. I could be out here paying these people back.
You know, you come across as very intelligent. Your record, your prior record is horrible from multiple states, same type of offenses, forgeries, thefts, things like that, from multiple states. You have 2 outstanding warrants from California, which apparently they're not that concerned to come out here and pick you up. But that being said, the court believes that from the beginning of this case, from the first time that we met, that I had treated you with dignity and respect. And I get repaid with that by accusations of being a racist from you, that people in this county are racist, which I dispute because I have sat through almost 100 jury trials, and I do have Black Americans that come in here and are defendants that juries, all white jurors have found them not guilty because they follow the law, which is what I always intended to do. To say that you were always compliant with the pretrial supervision is not accurate because one of the conditions of your bond was what? That you not smoke THC. I recognize that you have a medical marijuana card. I explained to you early on, I never enforced that. I never revoked your bond. I never threatened to revoke your bond with regard to that. But yet you've named that as one of your grounds in suing me as a violation of your rights. But you continued to do it despite my telling you you didn't. But now you've been diagnosed with severe cannabis use disorder. And what you fail to recognize is that the THC content in today's marijuana is so significantly high that it is affecting both your mental health and your physical health. But people don't want to recognize that because it's just something I've done since you were, 14 years old. You've smoked marijuana daily, and you don't want to stop doing it. So that's one thing. But you've also been diagnosed with some other mental health issues. So moving forward, knowing your position with regard to just that issue, when you have severe cannabis use disorder and a significant mental health disorder, the marijuana is making it worse. And you've heard me, you sat through a couple sentencing and I don't allow it because I've done the research and I know the significant mental health issues that it causes people that use it on a daily basis. And for people to say, well, I've used it since I was 14. I've had one of my veterans that stopped using it. He used it every day since he was 16 and he's now 40 something. So he stopped using it because he realized that I was right. He stopped using it. He gave it a chance. And he's like, well, yeah, I get it now. But some of your accusations, I think one of the accusations you leveled against the court was that I coerced some of the jurors into signing the verdict form. I have no idea where you got that because my contact with the jury is the same as yours. The only time I ever had contact with the jury was when I was sitting here and they're sitting over there and you were sitting there. I never have contact with jurors back there. I never once reached out to the sheriff's office. As far as you appearing here in a wheelchair, you didn't during the trial in January. In fact, for the prior year, while your case was pending, you never appeared. I knew you had a medical marijuana card, but you never appeared to be disabled or injured in any way. I was told the morning of the trial that you had recently had gallbladder surgery. You had your gallbladder removed. You asked for some dispensation for that. I think Mr. Gibbs inquired about you standing because your incision was uncomfortable. I said, sure, no problem. I complied. You had to use the bathroom? I said, sure, you can use the bathroom. I didn't stop the proceeding every time you used the bathroom. Then Mr. Gibbs waived your appearance because we wanted to keep things moving. But you consented to that. But yet you turn around and try to make it like I've done something against you personally, even to the extent of accusing me of telling the sheriff stuff. I don't tell Sheriff Riley how to run his jail, and he doesn't tell me how to run my courtroom. I have never once communicated with Sheriff Riley about you personally or your case. It's never happened. So it's kind of disheartening for you. Again, Mr. Rouse, I think you can be a productive member of society, but I keep coming back to it. There's something missing here. And again, part of the purposes and principles of sentencing is punishment. And as Ms. Tranter said, and what I said earlier about the victim in this case is not the 4 people that came in and testified that their names were forwards on this petition. They're not out anything. It's the citizens of the state of Ohio that are the victims in this case. So, is there something you wanted to say again?
Yeah, just again, like I said, I apologize that a lot of the stuff was a blur. I was on Oxycontin and promethazine during the trial. So a lot of
But you understand, sir, that I was never made aware of that. You never made me aware of that. So I was not aware to sit there and say that I forced you to go to trial where you were on these medications. I didn't know about it. I knew you had surgery. My wife had gallbladder surgery. And trust me when I say my wife had gallbladder surgery about 3 years ago. And within 3 days of that surgery, she was hosting a graduation party for our granddaughter with about 200 people there. So, I know about gallbladder surgery because my wife had it. So I know she had her gallbladder removed 3 years ago, but she hosted a party with 3 days after the surgery. And she wasn't. And again, I know people react differently to surgeries, but that's my frame of reference. And if there was some request for continuance that you had made or a further dispensations by the court, I would have considered them. But I can't do what I don't know. All right. I have considered the purposes and principles of sentencing, the relevant seriousness and recidivism factors. I know the state disagrees with me on this, but I am going to make a finding today that the 24 counts 13 through 24 are allied offenses of similar import in that they merge with the counts of the election fraud. Does the state have a preference as to which counts we proceed on, 1 through 12 or 13 through 24?
State would elect to proceed on the election falsification.
Okay,
1 through
so
12.
counts 1 through 12.
Yes,
All
correct.
right, so with that, the court is going to order you to serve 12 months in prison on count 1. And on counts 2 through 12, the court's going to order you to serve 12 months in prison on each of those, to be served concurrent with count 1. You have 52 days jail time credit, and you're indigent for the purpose of any fines, costs, or other financial sanctions. I recognize that this is a low-level felonies, but the court does find, based upon the type of offense in your prior record, that probation would not adequately punish you. The prison is necessary due to your extensive criminal history of similar conduct, and you have failed to respond to previous community control or supervision sanctions. Now, you're also subject to a discretionary period of post-release control, which means that upon your release, the adult parole authority may supervise you for up to 2 years. If you violate that supervision, the adult parole authority can return you to prison for up to 1/2 of this court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer. That time would run consecutive to any additional prison time you get sentenced to. The court does find that he's indigent for the purpose of any fines, costs, or other financial sanctions. We do have a right to appeal. In fact, I'm going to tell you right now, Mr. Rouse, I'm going to order Mr. Gibbs to file a notice of appeal on your behalf of both the jury verdict, any pretrial considerations, and this court's sentence. So I'm going to order him to file that within 30 days to preserve your right to appeal. I am then going to appoint to you appellate counsel. It will not be Mr. Gibbs that will represent you on the appeal. So just so that you know, I'm going to have him do that right away, get the notice of appeal, and I'll have new counsel appointed to handle that appeal. So I don't have to go anything further with the right of appeal. Ms. Tranter, is there anything else?
No, sir.
Mr. Gibbs?
Nothing further, Your Honor.
Mr. Rouse, I do wish you the best, sir, and I hope things work out. That's all. We're adjourned.